And with that, maybe just on the international perspective, I look to you, Sidharth. You've clearly done a lot of international arbitrations, and I know a case management conference in those arbitrations is super crucial and important. But can you share light on what are the kind of things that parties must look to include in such a initial case management conference? And is it a fetter on your flexibility, or is it actually necessary?
Thank you, Vikas. You have touched upon a very, very crucial aspect, one of the key aspects in any arbitration. Honorable Mr. Justice Hemant Gupta, esteemed dignitaries from the Ministry of Law and Justice, my fellow panelists, my friends from the media, ladies and gentlemen, namaste and a very good afternoon. Case management conferences, I'll just come straight to the answer because of the paucity of time. Case management conferences provide clarity, opportunity to cater to the relevant requirements of the particular case, an organized manner of progression of the matter, and most importantly, certainty and trust. A well-crafted procedural order number 1, and you asked, is there something that we should be looking at when we are drafting a procedural order number 1? A well-crafted procedural order number 1 minimizes procedural skirmishes and aids legal professionals like me who handle multiple matters. From the standpoint of litigants as well, who, as Ms. Yadav mentioned, are the most important stakeholder in the arbitration ecosystem, there is predictability and no surprises. If one looks at the Indian jurisprudence, there are many examples which suggest that principles of case management hearings increasingly find integration in our arbitration mechanisms now. This is to ensure efficiency and to streamline the dispute resolution process. Section 19 of the Arbitration and Conciliation Act empowers arbitral tribunals to determine their own procedures, subject of course to the agreement of the parties, and this helps tribunals to conduct a case management effectively. There are various judicial precedents as well which emphasize the importance of having a structured and a more definite, process followed in the arbitrations. The timelines for expedited hearings that we have in the Arbitration and Conciliation Act and the requirement to pass an award within a certain time frame, they all show and indicate the adoption of case management principles in our arbitration jurisprudence. And like you mentioned, taking a cue from the success of case management hearings in international arbitrations, they now find mention in our Commercial Courts Act as well. But how does one ensure that a case management hearing or a procedural order number 1 does not become an exercise in futility, and it does not unnecessarily fetter flexibility? So in my experience, regular monitoring of matters by tribunals, a periodical monitoring, ensures that there is momentum. In genuine cases where there is a need to deviate slightly from the agreed procedure or timelines, there should be flexibility to maneuver such situations. However, there are situations as well where lawyers and parties alike try to manipulate the process, and there it should be rigid enough so that there is no mockery of the system. I doubt there is anyone in this August gathering today who can suggest that a case management conference or a procedural order is a waste. Most institutional rules, and I was very happy to see even the IIAC rules, Rule 25, and Mr. Chandru threw some light on that, provides for a case management conference. Some institutional rules make it mandatory. ICC, I believe, makes it mandatory. SIAC has a provision, LCIA has a provision. So I can confirm from my experience that a well-defined structure at the very start of the arbitration process ensures that tribunals do not hold unnecessary hearings. So costs are taken care of. I have just 2 or 3 concerns which I have faced with case management hearings, where often at times terms of reference are also drawn. In multi-phase arbitrations, these early stage orders or procedural orders tend to become obsolete over a period of time. So as a practitioner, I always insist that when we are moving to the next phase of the arbitration, we have a fresh procedural order and we do not rely on procedural order number 1. And secondly, I have seen that when terms of reference are drawn, some parties during the currency of the arbitration or later when matters get to court try to misuse expressions used in terms of reference to suggest that the contract itself was modified, which can never be the case. And this is a guidance note for all the dignitaries present here, that when terms of reference are being drawn, please take due care to ensure that what you write there are no errors, because that can be misused to suggest the contract was amended or modified. A terms of reference is at the end of the day a document of convenience. It can't modify the underlying contract. So those are my 2 cents so far as this is concerned.
Thanks so much, Sidharth, and some very well made points there also. We then move to the next stage of arbitration, which is really the meat of it, the trial. And we'll explore if there are things that we can do to enhance efficiencies there. And here, Sidharth, I'll turn to you. In international arbitration, it's often the practice that you start with opening submission. So you start arguing the matter first, then go to cross-examination, and then closing submissions, which is usually in writing. Do you think that practice is desirable in India? Or, what's your view?
Sure, Vikas, thank you. And before I take that, I would also want to maybe say a few things about the memorial approach, because it all ties in with this. And I heard Ms. Sehgal, I heard Mr. Seth on their perspective regarding a memorial approach or a similar all cards on the table approach, where pleadings and evidence are everything is filed together at the very start. This is a hallmark of ICC arbitrations and other civil law jurisdictions, civil law influenced procedures. But the suitability of this approach, so far as Indian context is concerned, depends on various practical, cultural and legal factors. Because memorials approach is not something which is very commonly used in common law jurisdictions. And in my experience, and that's something which Mr. Seth also touched upon, this may not be very practical for India. Also answering your second part of the question, because we carry the legacy of court-like procedures, where we are used to following a certain sequence of pleadings, claim, defense, rejoinder. We then move to the stage of evidence, and then arguments followed by written submissions. Indian practitioners I have seen, including me, we are not always prepared in that sense to have a full-fledged pleading and evidence at the very start, especially when there is no discovery and production which has happened. We've seen that with Indian clients, we've seen that with various other foreign clients, that crucial documents are held back from the tribunals, from the other side. There are various Privy Council judgments commenting on this practice, and therefore that does not really work in our system. Front loading of all the evidence at the very commencement is also not very appropriate in smaller disputes, because it's not cost effective, it's very expensive. Now, taking specifically the question that you put regarding opening submissions, so because any procedure, so far as it ensures fairness and equal treatment, should be okay. However, the procedure that we generally follow in India is not that. We start with pleadings, how the case develops, what evidence is there. We then move to the next stage of cross-examination. What are we able to elicit from the witnesses, and then we go to the argument stage. But since there is party autonomy, there is that freedom which parties enjoy. They are free to develop any specific procedure that may want. In some cases, witness actions are dispensed with. There are arbitrations which are decided on the basis only of documents and oral hearings without the need for any elaborate evidence or cross-examinations. Opening submissions are requested by some tribunals at the very start, even in domestic arbitrations, where they want to get a context of what the dispute is like, and that actually helps. The opening submissions at that stage are not very elaborate. They are skeletal submissions, because you're giving an overview of the respective positions of the parties, and that helps tribunals to make an effective procedural order number 1 and an effective case management hearing to decide what they're going to face as the arbitration progresses. But I still believe that having a full-fledged opening submission even before witnesses have been cross-examined may not align with the legislative intent that we have in India and the procedures that we follow in India.
Fair. Okay, no, thank you so much, Sidharth.